Hi, once again, welcome to our webinar today. Today's webinar is about what to expect in your family law court case. So soon I'll be joined here by Michelle Dellino of Dellino Family Law Group. I want to first introduce myself. My name is Melissa Rosenberg, and I am a therapist in private practice here in Seattle. And one of my specialty areas is working with clients who are navigating divorce and separation at any stage. A lot of my clients are in the early stages of trying to determine whether or not that's the appropriate path for their relationship, or they're amid a difficult family law case, or they're picking up the pieces post-divorce and trying to navigate their next chapter. So I support clients throughout these different aspects of their divorce, and I work with both individuals and couples in therapy. But today I'm here as a moderator and a facilitator for this webinar. So in just a moment, I'll turn it over to Michelle to introduce herself and get started. But just to let you know, what we're going to do here today is deliver content. Michelle's going to talk a lot about what to expect in your family law court case. And you have the opportunity to ask questions. So the way that that works is a couple of different options. There's at the bottom of your Zoom screen, both a Q&A and a chat icon. So if you ask a question in the Q&A, you can go ahead and do that. And I'll pitch those questions to Michelle, and we'll answer as many of them as we can. Please note that in the Q&A that gets publicized to the group here. You do have the option of marking yourself as an anonymous attendee when asking a question. Otherwise, your name will pop up and doesn't really matter, but just want to make sure if you're comfortable with your name being attached to your question. The other option is you can ask questions in the chat, and anything that you ask in the chat will only come to me. And again, I will pitch those to Michelle, and we'll try to answer as many questions as we can for you guys today. Keep in mind also that we're not able to answer very case-specific questions. And so more general questions you can ask about the process. That's where we'll be able to actually, address content and deliver good information. So thanks again for being here. Hoping to, answer questions and give you guys a lot of great info today. I'll turn it over to Michelle now. Thanks.
Hi, thanks for joining us today. I'm Michelle Dellino. I am the owner and managing attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually handle cases all over Washington State as well. So today, we're going to get into some details. A little bit about me. I've been practicing family law for almost 15 years. I also have a background in criminal defense. So what that means is I'm really familiar with going to court. And in your family law case, there's a lot of different ways that you can approach it. Some involve litigation in court, and most actually do not. So we'll talk about that a little bit today when we talk about what to expect. So first thing for you to know also is that I am an attorney, but I'm not your attorney. Unless we have a contract with an attorney-client relationship, then in that case, I'm your attorney, and we can have confidential conversations offline, not in this webinar. But today, if you ask a question, I will do my best to give you some general advice and information, but nothing that I say should be construed as legal advice, and you should get your own attorney and have your own case-specific consultation where you can ask those questions. So just want to make that very clear from the outset. The goal here today is to get you some information, hopefully give you a little bit of assurance as you move forward as to what to expect in your case. Every case, though, I'll put this out there in the beginning, every case is different. And something that I run into a lot is everyone's like, well, my friend's case was like this. Well, my brother's uncle's case was like this. Well, so-and-so told me this should happen, or they got this. Friends and family are really well-meaning when you go through a divorce case. So as we talk about what to expect, it's important to realize you're going to have everybody wanting to tell you how it should be or what happened for them or someone they knew, and they mean well. But every case is different. Yeah, there are some basic principles and different fact patterns that things kind of fall into, but you should take your legal advice from someone that actually knows your case and the law in Washington, not what happened in their case, and not analogizing to that, even though they mean well. So that's something that'll give you peace of mind, and it's something that will help you as you move forward. Like, just say, thanks, that's great, I'm going to note that for later, but don't analogize your situation too closely to anyone else's, because it just kind of sets you up for success, disappointment, and frustration. So I hope that helps. As we get started, Melissa, what I'm going to do is I'm going to talk about maybe a couple sections at a time, and then we'll stop, because I know people often have questions as we go along, and it's easier than holding them to the end as well. So it's more important to me that I get you some information, but that I also answer your questions in a way that is helpful for everyone. So What to expect in your family law case. I bet you're wondering if you're here. Some of you might be in the middle of one. Some of you might be thinking about one. Some of you might be trying to avoid one. So everyone comes to thinking about a family law case in different ways. First thing I'll say is there's multiple types of family law cases. So I'll tell you what the most common types of cases are, and then we'll talk a little bit about what to expect in those and some common threads. First thing, divorce. Divorce is also known as dissolution. Dissolution of marriage is what we used to call it in Washington. And then a few years ago, we switched all of our forms and everything to a little bit more accessible terms, and it stopped being called a dissolution. But if you hear that term, it's the same thing. So divorce or dissolution. Then there's a divorce or dissolution with children, which has different requirements and ramifications than a divorce without children. So there's those two different types of divorces. Then there's a committed intimate relationship case. If you've watched my webinars before, you may have seen a webinar on committed intimate relationships. That's a very specific, nuanced issue, an area of the law, and it relates to unmarried couples that have cohabitated. It also relates to couples that may have cohabitated continuously for a significant period of time before a marriage. So there's committed intimate relationships that can be a standalone case, or that can be a component of your divorce case when evaluating property. So that's important for you to know. Another common type of case, some of you may be dealing with, is called a parenting plan modification. Parenting plan modifications are post-decree cases. So decree is like your final order. Case is over. Later, I want to change something. Parenting plan modification can be a major modification or a minor modification. So that's another common type of case. Then there are other post-decree issues, like somebody needs to hold somebody in contempt later. Somebody needs to enforce a final divorce order later. Someone needs to seek a relocation with their children later. So there's all of those types of cases. And then finally, another common type of case, which is also a family law case, usually along with a family law case, or sometimes as it's on its own, is a protection order. You might have a domestic violence protection order, an anti-harassment order, a sexual assault protection order. Those are a different type of case as well that differs from some of the things you're going to see in a divorce. So those are your common types of cases. And then the next thing to think about is, what style of a case is this? Is this a cooperative case where nobody's thinking they have to go to court? Everybody's exchanging information really amicably. Everybody has their own representation, but we're still exchanging information amicably. And we could go to court if we need to, but everybody would really rather avoid that and come to what I would call a cooperative resolution. Hopefully and ideally, that's most cases. Sometimes, though, in the middle of a cooperative case, something goes off track and we have to go to court, get a decision, and then we can kind of come back to the cooperative track. So maybe you're in that track, or maybe you're in a high conflict litigation track where everything needs to be decided in court. You might need an immediate restraining order when you start your case. You might need temporary orders like right away. There are more high conflict type litigation cases like that. Or maybe you're in a collaborative case where both parties have collaborative attorneys, and that is going to look very, very different than either of those first two types of situations. Or maybe you're pro se and you're trying to navigate this on your own and you're like, what the heck do I do? So that's another thing. So I've kind of given you 4 different types of styles, and really what to expect in each one is slightly different. And maybe you don't know like where you fall in, and that makes sense because sometimes you don't get to dictate it. Sometimes it's the other party, and you might be trying to move along and you're like, I'm cooperative, everything is cool, but the other party is doing and saying things that are going to force you to go down a road you didn't really want to. So you need to be ready to pivot for that as well. So we'll get into that. So I've identified some of the common types of cases, some of the common types of approaches, and I'm about to talk to you about some common threads, and then I'll talk about the way these different cases get started. But before I do, Melissa, is there a couple questions that you want to pitch to me to answer before I move on?
We have one question here. Question is, what immediate or quick manner can I take, action can I take when an ex hasn't paid full child support for almost 2 years? Taking out medical and other child expenses out of his total monthly child support obligation, even though the order says not to.
Okay, that's an easy one. So I'll answer that and we'll move on. That falls into, this is why I gave you some of these different types of cases. Where does this one fit? This is post-decree. This is post-decree enforcement. If he's not paying child support and he's deducting it and he's violating the order, you could seek a motion to enforce, or you could seek a motion for contempt. You would want to talk with an attorney about what's more advantageous for your situation. But if you don't do something to enforce the order, nothing's going to happen. If you seek contempt and you prevail, you'll get attorney's fees because it's a statutory thing where you have to. If you seek reasonable attorney fees, I should say. So your attorney's fees need to be reasonable. If you seek motion for enforcement, you might get the same. It really depends on what makes more sense for your documentation and situation. But the big takeaway here is if you are post-divorce and somebody is not doing what they're supposed to do under the orders, you need to enforce the orders. That's it. So I hope that's helpful. All right, as we talk about moving on and we talk about going forward, let's talk about some basics you need to know. I'll talk about how all these different types of cases start in a minute, but here's something everybody should know about what to expect in your family law case. If you are seeking money, like if you're seeking attorney fees, if you're seeking spousal support, if you're seeking child support, you are going to have to disclose your financials. Not everybody loves this. For a variety of reasons, but you're going to have to. If you're in King County, every county has slightly different rules on financial disclosures, but King County is going to require, and most of the counties are going to require, a financial declaration from a party if they are seeking money. Or if you're responding to a case where someone is seeking support and you're saying no, or you're saying it should look different, you're also going to have to provide financials. Both parties to any motion before the court seeking financials will have to provide a financial declaration laying forth what your expenses are, what your income is, how much you're spending on things. That's something that's going to have to happen. And the second part of that is you're going to have to file what are called financial source documents. The good news for you is those are going to be filed under seal. So they're in the court file, but they're not there for everyone to see them. And that's going to typically include 6 months of pay stubs or proof of income, 6 months of every account statement you have, whether it's a mortgage, whether it's a car payment, whether it's a retirement account, a bank account, a crypto account. It's a lot of statements. You have to provide all of those as well. You're also going to have to provide 2 years of your tax returns, and those should be full returns, including any schedules and W-2s. So be prepared to get those financials together. If you have a business, you're going to have to provide business bank accounts and the same documentation for your business, whatever you have available. So you're going to have to provide that. It doesn't matter if it's divorce with kids, without kids, parenting plan modification, child support modification, committed intimate relationship. If you are seeking financials or someone else is, you're going to need that documentation to support your request or why it shouldn't happen. And you're going to need a financial declaration. So that's like a really big takeaway that you need to have. People very often get to the point where they're like, I don't want to provide this. Well, you're going to have to. And if someone brings a motion, it's why a lot of the time, if we're trying to work something out in a cooperative vein, I'll be like, let's just exchange financials. You're going to save a lot of time and money by not making someone actually have to go to court to get them or serve you with discovery requests to get them. You're going to have to provide it anyway. So just get it organized and be ready to provide it because no one can really fully advise you on a settlement either if we don't have your financials. I mean, I can take your word for it, but I have a due diligence responsibility to actually make sure I see your financials before I say, sure, you're telling me you have $5 million. Oh, okay. Like that isn't going to work. And it's not going to work for the other party or their attorney either. So disclosure of financials is absolutely critical. The next, Melissa, should I go on or is there anything else before I go on?
I do have a few more questions.
All right, I'll take 2 more and then I'll move on to the next section.
Coming up here. Yeah. Well, somebody's asking if there's a recording of this. And so, yes, there is. There will be a recording of this on the YouTube channel, right? Is that right, Michelle?
Yeah, typically what happens is 2 things. Number one, I talk really fast to get you a lot of
She does.
information, and that can be really annoying to a lot of people, but sorry, it's just the way that it is. It gets you more information. It's how I think. So it's what's going to come across. But I don't expect you to retain everything that I'm saying. So lucky for you, this will be available on our YouTube channel. Most of my webinars are available there. So you're welcome to see them. If you want like little quick takeaways from what I say, a shameless plug is that I'm also on TikTok. So I'll give you like a 1-minute version at any time that you want to see it on there. And you can ask me questions on there and I'll typically answer them for you and 12,000 other people. So anyway, yes, that's available online.
Okay, great. Few questions here. One in the chat. In a high conflict situation, would you recommend filing for separation with a parenting plan ASAP and find an attorney after to get it done, or would waiting for it to file with an attorney be better?
I need you to say that again.
Yeah, I think they're saying if there's a high conflict situation, they don't have an attorney yet. Could you go ahead and file for a parenting plan and separation on your own, get an attorney later, or is it better to wait and do that with an
I would
attorney?
get an attorney ASAP because anything that you file, this is a big problem that we have. Someone files pro se, they file a petition for divorce. They make certain requests because they think they know what they should be asking for. Then they don't realize until later that what they asked for or didn't ask for or didn't preserve as something to ask for later foreclose those possibilities for them. Or the way to not respond to something without advice. You don't know what you don't know, right? Like, so you might think, oh, it's really easy. I know what I want to ask for, but you don't know the things that you should be asking for that aren't obvious or that aren't preserved. So, I mean, I'm not saying like that you have to have an attorney, but if you're going to go ahead without one, I would highly recommend that you at least consult with someone and review, or at least do a document review before you file anything. Because once you file it, you're kind of stuck with it. And yes, you can amend things later, but that can be difficult. And sometimes you need to get permission to amend. I had a case once where somebody didn't plead a request for something. They tried to come back and do it later in the 11th hour on the other side, and it was able to stop them from doing it. And it probably cost them a couple $100,000 because they didn't plead it properly in the first place. So be very, very, very careful if you're going to file something pro se. At least get some advice, even if you go ahead. Doing a divorce, getting a parenting plan, moving forward, this is kind of the most complicated legal proceeding you're ever going to go through. It's the most binding contractual relationship you can ever have with anyone financially. So it really would benefit you to at least get an overview. If you need immediate relief and it's like a protection order situation, go get a protection order by all means. That's something a DV advocate can walk you through. I still think it's better having counsel if you can, because we know exactly what to tell the court to get you an order if it's warranted. Advocates are also really good about helping you walk through those things. And that's different. That's a safety issue. I'm not saying wait on that. But if you're strategically looking at filing for divorce, get help. You're only going to benefit from that. Okay. So next thing I'm going to talk about. Let's just talk about divorce, because I think probably most people, not most people, but at least probably half of you are looking at a divorce with kids or a divorce without kids. So let's talk about a divorce and let's talk about a cooperative. And I'm not going to talk about collaborative right now. I'm going to talk about cooperative and litigation approaches. So a divorce. Every divorce case starts with a petition for divorce or dissolution, depending on what someone's going to call it. Final divorce order is something that's entered at the end of the case. We're nowhere close to that. I'm going to talk about King County as an example. So let's say, all right, I'm going to file for divorce and I'm going to do it in King County. That is a very simple thing to do. When you're going to file, that does two things for you. One, if you have not separated yet, it stops the marital community. Community property, and I've done community property webinars before, so you should watch those if you don't know what this means. But community property is basically the character. So the fact that both of you have an interest in any accounts, any assets, any debts during the marriage, possibly including a cohabitation period beforehand, you will both have an interest in it regardless of name on title. So simply put, every day you go to work and you earn a paycheck while you're still with that person and not separated, they have an interest in every dollar that you make. If you want that to stop, you need to file for divorce, or you need to take some action to end the marital community. You need to move out, you need to do something. So a lot of people do that by filing a petition, because then there's no question about it, right? Sometimes you'll file a petition way after you've already been separated. So I'm not talking about that situation, but filing a petition is a really good way to establish a date of separation. And when you do it, like I said, what you plead, which is what you put in that petition, is extremely important. It can look very basic. In my office, we call it a vanilla petition, because it's vanilla. It doesn't give all the specifics of how you're going to divide your property, because guess what? You don't know yet. You might think you know, but you don't know, and you want the flexibility to change that later. So you're going to use some language that's going to keep that option open for you later while you do discovery, while you figure out what there is to divide or what might be advantageous for you, because you don't know yet. Some cases you'll have worked out the whole case and then you'll file the petition, but that's probably where you've been working with counsel for a long time, where it might be a collaborative situation. So you're going to file that petition to establish the date of separation, or at least to say when it was in the past. And you're going to make requests. You're going to request the property to be divided fairly and equitably. You may or may not request spousal support. You may or may not request child support. You may or may not request a parenting plan. You may not request your attorney fees being paid, and other things. You're preserving those asks for later. You're not asking anyone to act on them right now when you file a petition, but you're preserving those things for later. So once you file a petition, then that starts the clock rolling as well. What to expect in your divorce about timing. This is super critical. The soonest you can get divorced in Washington is on the 91st day from filing and service. So that means you file a divorce, but you actually have to serve it on the other party, or they have to sign accepting service. 90 days after that service component has happened, you can finalize. But do most divorces with any assets or kids finalize in 90 days? No. Not if you actually want to do any due diligence, and not if like anyone has anything. That's really fast. And that typically doesn't happen unless everything is agreed or you have nothing. Typical timeline in a case, and this is important, you're going to feel like, I want this case over. If you've watched my stuff before, you've probably heard me mention my friend Rayford Palmer. He has a firm in Chicago. He's a brilliant divorce attorney, and he'll love it that I'm plugging his book again. He has a book that's called I Just Want This Done. That's how everybody feels, and it's a great book. You should read it. I get nothing for telling you this, except for it's really good, and it's on Amazon. But it's great because it's like how everybody feels is, I just want this done. Right? You do. But A marathon is what you're entering, not a sprint. You're not entering a sprint. It's going to be a marathon with a lot of different sprints. A sprint to get financials, a sprint to get maybe a temporary agreement in place, a sprint to get to mediation. But it's a series of sprints, and it's a marathon, and there's going to be times where nothing's happening. This is very frustrating for people. You just want this done. So the best thing you can do is find yourself some peace of mind while you work through the things you need to work through to be able to get this done. That's just the reality of the situation. So I like to give people the idea that 90 days from filing that petition is the soonest you could have it done. But a typical timeline in King County for a case with assets and or kids is anywhere from 6 months, which is low end. It's usually more like 9 to 14 months. That's just reality. And part of that is dictated by the fact that in King County and many other counties, there's a case schedule that's generated. That case schedule has certain deadlines, and you can't really force somebody to move faster. So you might want to move fast. Let's do financials. Let's go to mediation. Let's do all this. But if the other party's just sitting there like, nope, I'm going to wait for the deadline. Well, they don't have to mediate with you for 10 months. So they're just going to sit there and chill. And I can't make them do anything any faster. I can put pressure on them. I can make them comply with certain things. I can work on your case and get more information in the meantime, but I can't force them to settle the case sooner. So that is something that's out of our control. That's something to expect that you really need to understand. I hope that's helpful. But anyway, you filed the petition. Now what? The other party has 20 days to file a response. People also tend to freak out, especially people that are self-represented. They're like, oh my God, I got to file this. It's 21 days. I'm going to get defaulted. If you don't file a response, could the other party be defaulted? Yes, they could. Is that going to happen? No, you'll have to file a motion for default and then serve that motion for default. And then somebody could respond, or an attorney can file an appearance. And if there's an attorney on the case, they're not going to default you. So the idea of getting defaulted is not something to worry about. Does that response need to get done timely? Yes. But is it the end of the world if it's not done right within 20 days? No, no one's actually going to take action unless someone brings a motion. So that's something that you need to know. It might alleviate some stress for you if you're running up on having to file a petition, a response. Also, you should get advice in filing your response because, like I said, you ask for things in a petition, you ask or respond to things in a response, and you need to know if what you're responding to or asking to or denying or admitting is what you should be saying. So that's another thing to know. So you're going to file a petition, someone's going to file a response. If someone is served out of state under Washington law, instead of having 20 days to respond, they're going to have 60 days. They get longer. So let's say your spouse moved to California and you have them serve there, and then they have 60 days to respond. So it's not a huge thing, but it's something for you to know if you're serving somebody out of state. I could keep going, but I've talked about petition and response, and I'm assuming there's questions. So I'll take 3 questions right now as quickly as I can.
Yep, got a few questions. Okay, this attendee asks, they said, I understand mediation is mandatory in Washington, but how easy is it for a party to get relief from mediation granted by the court? Does the court frown upon a party that asks for relief from mediation during a divorce? I don't quite understand the question. Maybe you can just talk about,
Yeah.
yeah.
I think there's some confusion. Number one, I'll tell you something that might give you some peace of mind. At least I hope it does. I did a mediation yesterday, and it was great. We settled the case, and it was one of the most important days of that client's life. And it will be for you too when you go to mediation. Mediation's a huge day. So I'm going to talk about the role of mediation in divorce quickly and what to expect. But here's the thing I think that'll make you feel better. In basically not just Washington, but I'll just talk about Washington. There are a couple different rules. There are rules that govern the mediation process. Those rules keep mediation confidential. There's also a rule that's a universal rule called, you don't need to know the name of it. It helps me to say it, but you don't need to know it. It's called Evidence Rule 408. So you might hear an ER 408. An ER 408 can refer to an offer, or it can refer to any settlement discussions, which refers to everything that goes on in mediation. Nothing that you do in a settlement offer, whether it's under the umbrella of mediation or just sending a settlement offer to the other party, none of that can ever be brought up in court. The court doesn't want to hear about it. The court will sanction a party if they try and talk about it. If I, like yesterday, if I'm in a mediation and I'm like, we're making this offer. Let's say we hadn't settled that case and we ended up in court later. If we ended up in court later and the other party was like, well, wait a second, they said they'd take $50,000 at mediation back in February. They can't say that, and the court would be, that would be objectionable, and the court would be pretty upset if somebody did that. So in mediation, you have the whole reason that you have this process is to encourage settlement. Family courts don't want to make decisions about your kids. They don't want to make decisions about your money. They don't want to make decisions about your business. They frankly want you to figure it out. And sometimes when you end up in a trial, they want to feel like you did everything you could, which is why there's a mediation requirement. So a court doesn't frown on anybody going to mediation. They require it. Every county right now, Pierce didn't used to, but now they do. King, Pearson, Snohomish, Kitsap, they all require some form of dispute resolution before you can go to trial. So no one frowns on you going to mediation, they require it. No one can force you to settle in mediation. Mediation is a voluntary process, but if you do the right kind of mediation, and I can talk about that in a minute, it's very highly likely that you're going to settle your case. 95% of my cases and any competent attorney's cases settle in a shuttle mediation. The reason that they do is because the return on investment of going to trial is not high, it's not certain, and there's a risk. However, those 5% of cases where there's a real reason to go to trial, we go to trial. So, but anyway, long story short, no one's going to look down on you for going to mediation. They require it. I actually have another case right now where the other party won't agree to mediate, and so we have to bring a motion to either force them to mediation or waive it, and that person's going to have to pay attorney fees for not doing it because that case schedule I was talking about, it requires it. You have to go unless there's domestic violence or some other reason that it should be waived. So anyway, I hope that's helpful. Don't worry about it. Go to mediation, make the offers you want to make the settlement offers, and know that it's protected. So hopefully that gives you like a little bit of peace of mind when you start to think about it. Okay.
Thank you. Yeah, a few more questions here. Somebody's asking if you have any recommendations for how to get organized, tools or resources when it comes to organizing yourself around this process.
Yeah, well, good news for you. We're going to put out a divorce organizer that you can download and use. I'm working on that right now in my copious amounts of free time. And that'll tell you all the documents you need and what you need to do with them. But until then, I would recommend that you organize your financials. Basics do this. Set up a folder on your desktop, on your computer, and take some time. Make your list. 6 months of every statement. Make a list of what all those statements are, and in your folder, make a subfolder for every single one. Doing this is going to save you time and money with your attorney, because then you can be like, here's my folder, and your attorney's going to be like, oh my gosh, how did you organize this the way that we would? And how did you know what to do? Because a lot of clients will just send us everything in one thing. It's a mess. We don't know what's what. It's not named properly, or you're sending me JPEGs and pictures from your phone, and that's not a statement I can use. So download the statements. If you have Chase Bank, go to Chase and download 6 months of every account and put them each in an individual folder. If you have a Fidelity retirement portfolio, 6 months of that in a Fidelity folder. If you have a car loan, 6 months of that in a folder. Do that for all of your accounts. It's going to get you started. And then put a tax return folder. I would even say 3 years. If you have 3 years of personal and business taxes, do that. If you only have 2, that's fine. 2 is going to be what's required. I like to say 3 just because it gives us a bigger picture, but 2 is fine. Then you'll have another folder that says income, 6 months of pay stubs. If you can do a year, do a year. And get all of that and put it in one folder and be like, here's my financial folder. Here's the other thing to know and expect in your case. You're going to have to update that. I just told you your divorce is a marathon. It's not a sprint. So we're going to need them to get started. And then 6 months go by, you're going to need to update them. So be prepared to update them. Don't get annoyed when someone asks you for updated financials and be like, I already gave you financials. That's true, but we need real-time data and current data. We also need to know how much of those financials represent post-separation. I told you about that data separation. I'm going to earn money in the next 6 months. It's going to go into my separate, my separate column. So we need to know what that number is as well. So be prepared to organize your financials. The way I just described in the folder system is the best thing you can do. As far as naming them, I highly recommend that you also name your financials. Everyone has their own system, but our system is start with a date. So it would be 2024.02.08. And then it would say Chase, the last 4 numbers, Chase 1234. That's my account, October. Whatever. So go through and name them. You doing that is going to save you on paying a legal assistant to do it. And we have to have them organized and do it. Like, it's not a choice. So you have to do it. So if you do it, you've saved yourself time and money. That's one thing. The other thing I would do, Melissa can chime in on this as well before we move on, is organize your resources. You need 3 kinds of resources. One, you need financial resources. You need to know how you're going to pay for this. Maybe the other party is going to pay fees and you need to bring a motion because you don't work. Maybe there's a community account. Maybe you have a community credit card, but you're going to need to pay for help. And the thing for you to know is that An automatic temporary financial restraint goes into place in cases that says you can't spend money out of the course of ordinary usage in counties like King and Snohomish and Pierce. And that's all very true, but you can spend it on attorney fees. So you need to know how you're going to pay for that, or if you're going to need to get some help for that, because the worst thing that can happen is you no longer have help for your case, and now you're stuck because you couldn't pay and you don't know what to do. And I'm not just saying that because I'm an attorney, I'm saying that because like I also work with a lot of clients in volunteer situations, and they often are like, I didn't know what this was going to cost money. I didn't know what to do. And now I'm on my own. And this is really scary and overwhelming. So have a plan, gather those resources. Second thing is gather your emotional resources, which is something Melissa could talk about too, because it's a huge, huge thing. You're in this for the long haul, and you're going to need people that support you. You're going to need to talk to a therapist, even if you don't have one, because if not, you're going to spend a lot of time and money trying to talk to your attorney about what's going on emotionally. And although I really want to hear it, I also I'm not equipped to help you the way that you need to be helped, and my rate's a lot more than a therapy rate for something that's not helpful. So you're going to want to do that. You're going to want to have your close circle of friends and family that you can rely on, and that's going to be important. And you're going to emotionally not want to post about this on social media, because if you do, that could be used against you, and that's not good. So emotionally, lock it down and get it under control. And Melissa deals with a lot of people going through this. I think you probably could offer something helpful.
Yeah, just to piggyback on that, I work with a lot of clients who are trying to stay organized in their divorce process. And that was the question, around how do I prepare for my meetings with my attorney? How do I prepare for mediation? How do I emotionally prepare for those things? Because the thing is, when you're trying to keep your ducks in a row with the financials and the paperwork and the different, logistical components of the divorce, there's also complex emotions associated with the divorce, and they're going to muddy the waters. They're going to make it difficult for you to stay organized unless you have appropriate support. It's still going to be hard, but it's going to be, more doable. And you're going to find a lot, you're going to be able to cope a lot better with the process and compartmentalizing the process the way you need to, if you can, access the appropriate level of emotional support. So like Michelle said, working with a therapist is extremely effective and useful and often vital in this process. And also having people in your life who can support you through it, who support your ability to exercise self-care, find what works for you, but make sure that you have others who are supportive in your life in that process.
Yeah, it's extremely important.
Yeah.
So financial resources, emotional resources, can't stress that enough. Absolutely. Yeah. Okay. One more, and then I'll move on to my next section.
Okay. This person says that their divorce started amicable and is now turned. They own a business along with their family situation. Anyways, they were told that, like you had mentioned, a restraint on moving funds or opening new business accounts. Let's see. As I was told, there was restraint on the moving of funds, opening new business accounts, coming into my house, and still taking things when I'm not here. Okay. I need immediately relief, and I need to save our company. How to speed this up? I guess maybe there's
basically at the end of the day, no one's that doesn't mean anything. Like, and I think any attorney will explain this to you. Yeah, there's an automatic temporary financial restraint in place. And if someone is doing something, then you need to bring a motion. So basically what you need to do is tell your counsel what they've taken exactly, and if you need to bring a motion. And the first thing you should do is ask them to put it back, because the court, if you just run to the court and say, hey, this person took this and violated the order, it looks better, and it's more likely if you just, did you ask them to put it back? No? Okay, well, maybe they didn't realize, especially if the other party is self-represented. This happens a lot where somebody will take money and not realize it violated the order. So you're going to want to make sure and ask them to put it back, and have your attorney ask them to put it back if you have one, and tell your attorney specifically what it is. So, but the order, the automatic temporary financial restraint, that doesn't stop anyone from doing anything. It's a piece of paper. Like, there's no way that a court could like freeze all of everyone's accounts everywhere. They can't do that. Like, it doesn't work that way. So you have something that you can use for enforcement. Very often it's not used until the end of the case, where you're like, hey, this person took this money, and it should be treated as what we call a pre-distribution to them, because they already took it. But if it's something where it's affecting your business or your future, then you need to ask for it to be put back. So you need to be very clear about what it is, why it's hurting things, and get it put back. Or you need to, in the least, keep track of it for later. So that's really all you can do. And you need to take action on it, or you need to note it and deal with it in settlement, depending on the veracity of the situation. So I hope that helps.
Yeah, definitely. I have a few more questions, but if you want to go into some other
All right,
things.
I'll take one more, and then I want to talk about a few other things.
Just on the topic of payment and fees, what happens with attorney fees, assuming both parties pay their own fees? Do the costs get deducted from marital assets that were left at the moment of separation. I guess
No, I mean, it depends on how you're paying them. If you guys have an agreement and you're both paying fees out of like a community account, like let's say you have a savings account and you're both paying fees out of that, that's fine. I mean, then you're paying fees out of that and then what's left is left, right? But if you're paying your own fees post separation on your own credit, most people pay fees on a credit card and then they pay for it later. That's usually what happens. But if you're taking the money out of like a community account or putting it on a community card, there's a lot of different ways to deal with it. So it depends on how you're paying fees, but no one's going back and like deducting money later unless there's an agreement that the community is paying the fees. If there is, then you're each paying fees on a credit card, and then maybe you can have an agreement later, or you can work it out at mediation. Let's say I spent 15,000 and he spent 10,000, and then we can true up and take that and pay our respective credit cards off out of a community account. Sometimes that happens, but sometimes people are just responsible for their own fees and paying them on their own out of their own post-separation money. So it depends. A lot of different ways that you can deal with fees.
Okay.
One thing I'll talk about when we talk about what to expect, we talked about filing a petition and responding to a petition, but this last caller asked, not caller, but listener asked, what if you need immediate relief? If you need immediate relief, then you got to file a motion. It's going to cost you time and money. So you better only do it if it's really important and you need to. Then what you do is you can seek a motion. Two kinds of motions you could bring during the case. One, a motion for temporary orders. If you need a temporary parenting plan, temporary spousal support, or other kind of temporary relief, something to stabilize the case, you can do that. It's going to take a little while to get in front of the court on it, but you can do it. And that will have a court make a temporary decision about who's going to control persons or property, who's going to control what's going to happen with the parenting plan. All of that kind of stuff is going to be out there. Okay, so you can seek that in temporary relief. This person was saying, I think, like this person's violating the order. You could seek a motion for contempt of that automatic temporary financial restraint in the middle of the case too. Contempt doesn't have to only be post-divorce. So if it's something where someone's taken something and they won't give it back, well, you could go to court on contempt and ask for the court to order them to put it back. Or sometimes the court will say, yeah, they shouldn't have taken it, but it's going to come out of their settlement at the end. It really depends on the specifics. So there is an expectation that you can get relief in the middle of your case. It just depends on what the specifics are and if it makes sense. A lot of the time it does. Sometimes when you file a case, you will file a motion for temporary orders right then if you need immediate relief the minute that you filed the case. A lot of the time, though, people don't, and they think everything's going to be really amicable, and then all of a sudden it turns out not to be, and then you need to reevaluate. So I hope that makes sense. I would say another next thing to talk about. We talked about financials. You always have to expect to disclose them. You have to expect that you might need to get relief in the middle of the case, even if you didn't think you were going to. And then we talked about the need to update your financials. Here's the other thing to know. And we'll talk about this on the financial end because it applies to any kind of financial case, especially divorce. If you have assets, you're going to have to value them. It can't just be like, oh, I have a retirement account and part of it I contributed to before we were married, and part of it I contributed to during, and I'm just going to tell you what the values are. That doesn't work that way. You'll need to have a professional valuation done. Your attorney will do that. If there are mixed accounts that are separate in community, you'll need to have a valuation done to determine what the values are of each portion, because you'll need a professional to calculate the gains and losses on the separate community portion. So anyway, expect to value your assets. If you have a home and you're not selling it by agreement, expect to have to get an appraisal. And you don't have to do that. That will be done for you. You'll need an appraisal that it's not an appraisal from a refinance. It's not an appraisal for purposes of real estate. It's an appraisal just for the purpose of your divorce, and it really can't be used for any other purpose, but you're going to need that. And don't use Redfin, or do expect not to use Redfin or Zillow. I think any competent realtor will also tell you, and any attorney will tell you, that those values are completely speculative. They can be off by tens of thousands of dollars, and that's not what you want to base your settlement on. So you're better off getting an appraisal, and that's what's only going to be admissible in court. You can't go to court and no one can come in and testify about a Zillow or Redfin value. So be prepared that you're going to, even if you're just in mediation, need an appraisal to actually back up the value on any real property. So you can expect to do that. The other thing that you can expect is if you have parenting, you got parenting issues, it's a high conflict parenting situation, and you got young kids, and you can't agree on a parenting plan, and one person wants 50-50 time, one person wants to be primary, expect that you're going to have a custody evaluation done. That custody evaluation might be by Family Court Services, which is a requirement in King County if you don't have a private evaluation done. It might be by CASA, which are court-appointed special advocates for lower income situations, but run by volunteers. But if you have them the money and the means and you have a real custody problem, expect that you're going to need a guardian ad litem or a parenting evaluator. That person is going to do an evaluation. They're going to meet with you. They're going to meet with the other party. They're going to meet with your kids. They're going to meet with other collateral contacts, counselors, therapists, other people in your life, and they're going to make a recommendation on a parenting plan. And that's not necessarily what's going to happen, but it's very persuasive for the court and it's important for you. And if you don't like that evaluation or you think they did a bad job and you have counsel, be prepared that you're going to have to get an expert to challenge it if you don't like it. So you need to know that when I talked about the marathon component, there's going to be things you got to do in the asset silo. There's things you got to do in the custody silo. If everybody agrees on everything, or you have counsel and we're able to just say, hey, this is what it looks like, and you have two people that know what's going to happen to a certain point of view, a lot of the times, even in high conflict situations, counsel can help guide their clients towards a good resolution. So it doesn't necessarily mean you're going to go down a full-blown fight on everything, but be prepared that these are things that are necessary in these kinds of cases. And that's important for you to know as you move forward. So expect these are the types of cases. Expect these are different approaches. Not every approach is the same. Expect not to rely on your friends and family to hear about what happened in their case because they don't know your case or the law. Expect to have to make financial disclosures. Expect to have to get values. Expect in custody to potentially have to get experts involved. So, and expect to have to get a therapist to help you through it. Like that's really hopefully a good takeaway for you. I will take a couple more.
Okay, bunch of questions. Okay, if my parents gave money through a 529 in my name for the kids, is that money considered community or separate property?
I love the 529 question. Good question. So 529s go on a spreadsheet and the name who's on it, that the money's for your kids. So there's no value attributed to the community. It's a community asset, but it's for benefit of your kids. So it's not an account that can be divided. So it'll go on the spreadsheet to recognize who's controlling it, but it's not going to be counted in your portion of the community. So let's say you've got a 529, your parents contributed to it, you contributed to it, whatever. It's $100,000. So it might go in your column because it's for benefit of your kids and your name's on it, but it's going to be X'd out as far as the value goes. It's just going to show who's controlling it. It's not going to reduce your portion of the community because those aren't assets that are available to you. So that's an easy answer. One more.
Okay.
Maybe two more.
Got started with dissolution of marriage papers a few days ago, which means the end of community property has been established. How does it work out if there are credit cards that are under the other party's name that I share with them? Those cards were used for groceries and expenses and the upkeep of the family. Does that mean I can't use those cards anymore? The other party is in the same house. We have a child together.
No, you can still use the cards. It doesn't change. You can do whatever you've been doing that's in the normal course of business. It might mean later post-separation that we're figuring out who spent what, or it might mean that you guys are still like sharing finances. And at the end of the case, even though separation's been established, you guys just decide to split paying off the card. It can mean a number of things, but it doesn't mean that you have to start using the card at all. I mean, if that's your way of paying for things, you should continue doing that unless there's an order that says otherwise. That's an easy one too. Good questions.
If you have separate bank accounts, is that also considered community property?
Yeah, this is important for you to know. I'll give you my high level on community property. And it's interesting because a lot of people hear that term, don't really know what it means. And why should you, right? Like, I hope you don't unless you're involved in a divorce. So community property state means, think of it like this. You're not sitting here with me. I draw when I talk sometimes. So I'll draw a big circle and big pot. And I'll be like, here's the community. And that community started when you got together and it ended on the other side in that circle when you separated, right? Even if it was just, even if you're living together and someone filed a petition, what's in the community is the first thing you need to establish. Your house, your bank accounts, whether they're in your name or the other party's name. You might have had separate accounts during your whole marriage, but those accounts are all community. So everything goes in there, every asset, every debt too, every credit card, everything. And then at the end, when you're settling, you're going to also look at what am I backing out? So if you got funds during that time and it went into the pot and it was something you inherited just to you or a gift just to you, you're going to back that out. Or if you have an account that was earning interest from contributions you made before the marriage, you're going to back that portion out. And then you're left with what's in there. And the next question then becomes, how do I divide it? Well, in some states like California, it's a 50-50 state. No one cares how long you've been married. No one cares how much money you're making. Everything's going to be split in half. We do not benefit from a 50-50 law here. We're not a 50-50 state. That's a really common misconception. Everybody thinks community property means 50-50. Bingo, wrong. It does not. We are what's called a just and equitable state. What is that supposed to mean? It's supposed to mean whatever's fair. Well, if you're going into a divorce case, here's another expect. Expect that if you hear what's fair, there's two kinds of fair. There's one, when you go on a bus or Sound Transit or whatever, you pay, and that's a fare that you pay. That's easy to quantify. That's fair. The other is if you go to the Puyallup or the Evergreen, you actually go to a fair and have a good time, that's fair. Otherwise, don't ever mention that word in divorce, because what you think is fair is not going to be what your spouse thinks is fair. Take that word out. Every client says to me, well, that's not fair. And I'm kind of like, I like you and I'm trying to help you, but nobody cares. So don't talk about what's fair. Instead, talk about what's equitable. So Washington law looks at different factors in determining how to divide that pot. It looks at how long you've been married. It looks at what are the financial resources of the parties at the time of separation. And it looks like what your future potential is going to look like, right? And it also looks at if there's kids at home and you're trying to support them in both households. So then the court's going to figure out what's equitable. It's not about what one person or the other thinks is fair. It's about what's equitable in this situation under these facts, okay? So that's a very fact-specific analysis. For me to tell you one person's going to get 60% of the community, another person's going to get 40, that's very possible. Completely possible, but it also could be, it's going to be 50-50, or it could be even more or less, or it could be 50-50 plus spousal maintenance. It's going to depend on your individual situation and what happened and what your situation is, how to divide that pot. But this person's question initially was just, what if you have separate accounts? The answer is those separate accounts are still in the community. I always tell people this, name on title does not matter in a community property state. When I say name on title to a bank account, a vehicle, a home, it doesn't matter. A lot of people will say, well, I'm the one that saved that money. I'm the one that contributed to it. I'm the one that did this or that. That might be true. And I'm not diminishing that, but if you did it during the marriage, it doesn't matter. It doesn't matter at all. If you did it before the marriage and you used pre-marriage funds to put down on a property or something, that's totally different. That does matter. But if you were the one that did all the heavy lifting during the marriage and now you're upset about it, I get that. Like that, a lot of people feel like that. I was the saver, I was the planner, but nobody cares. Like those are the choices that you made in your marriage. So name on title to accounts doesn't matter unless it's an inherited account or a gifted account. I hope that helps. I'll take another one.
Great. Okay. My spouse has not paid for mortgage, auto loan, or childcare since I stated I wanted a divorce. We've now served him with a temporary DVPO. What steps do I need to take with my lawyer to ensure I start getting paid?
A DVPO has nothing to do with child support or spousal support or bills. A DVPO is an order for protections, domestic violence protection order, asking a party to stay away from you. It might, in some cases, it'll say, you get to be the one staying in the home right now, but it hasn't anything to do with financial relief. So you're going to want to work with your attorney to also serve a motion for temporary orders, specifically asking for the spousal support or child support that you need. That's what you got to do. You might do it at the same time as the DVPO, but you don't, the DVPO is not going to give you child support or spousal support.
Can you talk about what the cost range is for a divorce with attorney fees and specifically with kids and going to trial?
Yeah. I don't mean to chuckle about this, but I hate it when people ask this because there's a reason that a fee agreement says what it says, and it's irresponsible when an attorney tells you it's going to cost you this much. I'll talk to you about range in a minute, I will. But the answer is what everyone hates to hear. It depends. I'm not interested in telling my clients or anybody listening to me for information what they want to hear. Some attorneys will be like, oh, it's going to cost you this much. And they're telling you that because they want to give you reassurance and they want you to hire them. I'm never going to do that. That's not helpful to you. The answer is it depends, because I think I said this earlier, or maybe this was another time, I don't know, but you might be committed to keeping costs down. You might be committed to being amicable. You might be like, here's my financials, let's cooperate. You might be like, here's a parenting plan, let's work on it. You cannot control what the other person is going to do, and you might have to respond to it, or you might have to take more aggressive action than you thought, and that's going to cost you time and money. Or you might realize everybody's not that far apart and you can come to an easier resolution than you thought. So I've had divorces cost less than $5,000 significantly, and I've had divorces cost $150,000 for one person. So it depends on the level of conflict. It depends on whether you end up in a trial setting, whether you just end up in a mediation, you're able to resolve there, or whether you're able to resolve through negotiation. The less conflict that you have, the more cost effective your case is going to be. The more contentious your case gets, the more emails you're sending your attorney asking a million questions, which isn't a bad thing, by the way. The more that you're not, here's another tip for you. Organize your emails and your thoughts. Send one email every couple of days with everything. Do not send 4 or 5 emails over the days. Then we've got to look at them all. We have to respond to them all. It's taking you more time and money. Don't do that. If it's an emergency, sure, of course. But if it's not, like, try to condense your communication, because when we're talking about costs, the number one thing that drives it up is everybody sending me every little text message or this or that, that sure, it's important and I want to see it, but it could have waited till the end of the week in one spot in one folder. So then we upload it in one place and we review it at once, not 4 or 5 times. So it's important for you to know that. And it's emotional time. You reach out, you want to do this or that, you want to get resolution, but be thoughtful and intentional with that. I think is very helpful. So when you're thinking about costs, the average, I can tell you like averages, but that doesn't really mean anything for your situation. A divorce with kids and assets, each party that's not even that contentious, but that has stuff to unwind, each party's probably going to spend between $12,000 and $20,000. And the end of the day, though, that might be like, oh my God, that's a lot of money. Right. But if you have assets, especially, I've had people try to DIY it, go to a self mediator with somebody, then they come and they look at you and they say, hey, this is what we agreed on. Can you draft it and sign off on it? And I'm like, sure, but you're leaving like $300,000 on the table by agreeing to this. Oh, I guess I should have spent that money for representation. 20,000 sounds pretty good when the ROI is like 300, and then they have to start over. I'm not saying that always happens, but it happens a lot because you don't know what you don't know. You might think we work this out amongst ourselves and we're doing a 50-50 and that sounds great, but you don't know what's just and equitable, and we're not a 50-50 state. And you might have been a stay-at-home mom and maybe you're entitled to 60%, and maybe that's a lot more money, or you're entitled to more spousal support and that's a lot more money, or you're paying too much, you're on the other side of it and you're like, oh my God, and you probably shouldn't have been. So you don't know what you don't know. So spending money on fees, and I'm literally not just saying this because I'm an attorney, I would never let a friend or family member be unrepresented. I would not represent them, but I would not let them be unrepresented at all. At least in negotiating a resolution. So you could an average 12 to 20,000 if you have stuff to unwind and you do it in a competent way, because you're going to have to get valuations on things. You're going to have to get appraisals. You're going to have to talk to people. You're going to have a settlement proposal put together. You're going to have a parenting plan drafted. You're going to have to go to mediation. This stuff takes time. So the less conflict it is, then you throw court into that and it gets even more expensive, and you throw trial into that. And the average cost of a family law trial, I think last year in King County, is around $55,000 a side. So that's why you don't really go to a trial unless it makes sense. That's why most cases, as long as we get you into a range of risk of what could happen, what's equitable, you're probably going to settle on that because it's better for most people. No one's going to settle on their best day. No one's going to settle on their worst day. People are going to settle somewhere in between. And usually we can make that happen for you and make it far more cost effective than a trial. And you leave knowing I didn't leave all this money on the table because I gave up my whole business interest, or I gave up my whole 401k and I didn't have to do that. Like, you don't know. And you need help figuring out, is it better for me to hold on to pre or post-tax assets? The type of assets you take in settlement is extremely important. And so I like to work with my clients on what exactly is in your portfolio? What benefits you now? How old are you? What are your next years going to look like? All of these things are very important, but they take time and money. The lower conflict you have, the less your case is going to cost. But if you have high conflict, that's when you need help the most. So it's kind of a catch-22. What I wish for everyone is a very cooperative and amicable situation where we're helping you, guiding you through it, and no one is throwing mud at each other or going to court. That's what I hope for everyone, but that can't always happen.
Michelle, you mentioned earlier, if you own multiple properties, an appraiser likely needs to be hired for all of them. Would we be splitting the cost, or who pays for that?
There's 2 different ways you can handle appraisals. It's funny, sometimes depending on the situation, it makes sense to do what we call joint appraisals, where the parties stipulate that whatever this appraiser says is going to be the value we use, and you each split half and half. That saves you money, but it's not always what you want. Sometimes if you think that the values of the home are super important to you, I recommend my clients that we get our own appraisals, and you shouldn't get them yourself either. You should always have your attorney. I was explaining this to a client the other day. The client was like, oh, I know how to get an appraiser. I'll get one. And I'm like, no, please don't. Because if you get an appraiser and we don't like that appraisal and it's too high and we don't want to use it, you will have to disclose it if they ask for it. If they serve discovery, you'll have to disclose it. If your attorney gets it, which is what we do, we hire the appraiser on your behalf and we get it. If we don't like it, we don't have to use it. We can get another one. And if they ask for any appraisals that we might have done, we don't have to provide them because they're attorney work product and they're privileged. So you have to be smart about it. Anytime you get an appraisal, you've put that value out there. So if you guys are stipulating and agreeing and your counsel agrees that it's a good idea to do that, that can be a good way to go. Totally. But other times, if there might be a discrepancy in value and you want to make sure you get an appraisal that's advantageous for you, you should get your own. So it really depends on the circumstances. Also, if you're going to have an agreement to sell the properties, you don't need an appraisal because the value is going to be whatever the value is going to be when you sell it. So a lot of the time, though, we don't know if people are going to agree to that. They might change their minds. And so you want a value anchor to be able to anchor what the value is at a mediation or in settlement. I hope that's helpful. We have like 5 minutes, so I'll take a few more. I think I've given some takeaways. I'd love to give you more, but we'll have to do that. It's a part 2 another day.
Definitely. Okay, we'll try to blast for a couple more before we finish up here in 5. Can we also talk about what the actual temporary family law order, TFLO, will look like in court?
Oh yeah, I'll tell you what it'll look like. It'll look like nothing that you want to be a part of. It'll look like a 5-minute argument from either side. You spent all this time and all this money putting together this paperwork. And I'll tell you this too, a temporary family law order argument is for show. It's for show. It's for you, the client. It's for you to feel like I went to court and I fought for you. That's what it's for. It's not for most, and I'm not trying to be like off the cuff about this. I'm trying to be real with you here. So when you go to a temporary family law order hearing, you've already, one person's filed a moving documents and a bunch of paperwork. The other person's filed a bunch of responses and the other person's filed a reply. And all of that is sent to the court way ahead of time. And so the court has read that. They should have anyway. They've read that. And they've pretty much 90% of the time already decided what to do before you show up for that hearing. You show up for the hearing. It's a non-testimonial hearing. If you're the client, you will not speak. Your attorney will speak for you. The moving party will get 5 minutes. Usually if I'm arguing, I'll say I want 5 minutes and I want to save 1 minute for the end. And I can blast through a lot in 1 minute. So I'll hold my 1 minute until the end because I'm the moving party. So I'll go blah, blah, blah. I'll go on everything you need to know for 4 minutes that's already in what we filed. And maybe the court will have a question or two. Most of the time they won't. The other party will then respond. They'll have their 5 minutes to blast through everything. And then I'll usually save like a minute for the end and I'll come back and say it. Or maybe I'm the person responding and I'm responding to what the first person argued. You can't argue anything that what we call is outside of the pleadings. It's not in what you already submitted. But the big takeaway here is that the court's already decided because they've read everything. So anything I'm saying is nothing new. Sometimes the court will have read everything and have a few questions or things that they're holding on to, and they'll want to hear from the parties and they'll use that time to say, well, what about this? What about that? What about income? Tell me about this, something that wasn't covered in the pleadings. And that might make a difference. But 90% of the time, the court knows what it's going to do before the attorneys ever turn on the camera on Zoom or step foot into the courtroom. So when I say it's for show, it really is. And a lot of the time I hear from people and they're like, well, my attorney did a really bad job. And I'm like, well, the court probably already knew what they were going to do. You just didn't feel confident in it. And you wanted somebody that was going to say X, Y, Z, this is why it is. This is what should happen. Tell me this and that. I will never leave an argument having somebody feel like I didn't fight for them because it's important and because it's clear for the court. But most of the time, the court's decided what they're going to do. So more important than the argument are the pleadings and the motions and the declarations that you filed ahead of time. If those are good and those are solid, that's what's really going to make a difference for your case. And then after the argument, the court will typically issue an order right on the spot. And sometimes they'll use one of the proposed orders one of the attorneys sent in and edit it. Sometimes they'll ask the attorneys to work together after the hearing to edit the order. There'll be an order generated, though, pretty quickly. On a rare occasion, which does happen, a court will say, I'm going to take this under advisement because I don't know what to do. And then they'll issue a decision later. That doesn't always happen on temporary family law orders. I think it happens less than 10% of the time, but sometimes it happens. So you're going to have an argument that's short and hot and fast. You're going to have submitted a bunch of stuff beforehand and you're going to get a decision that day. And if you don't like it and a commissioner issued the decision, then you have 10 days from that time to seek revision by a judge or trial judge to decide if they want to make a change. Most of the time they don't. Sometimes they do. I lost a contempt hearing about a month or two ago that I shouldn't have lost. And I was pretty ticked about it, but we lost. And so then we sought revision. And then the judge was like, yeah, you shouldn't have lost. And then they found contempt on revision. So that was lovely. And it was nice for my client. And it was nice for me. But a lot of the time you get a decision, you send it up on revision and the court's like, I'm going to leave it like it is. So don't count on revision as to change what happens in your temporary family law orders hearing. Temporary family law orders hearings are extremely important because they can set the tone for your case. And your written materials are the most important thing. That's why I recommend you get counsel and don't try to do it on your own. I hope that helps.
Okay, we are at the end here. I'm just going to ask one last question because it's a quick one, I believe.
Oh.
Please remind us the date of separation? Is it the date I submitted for temporary order, or is it the date he actually moved out?
It depends. It might be when you filed your petition for divorce. It might be when you moved out. I had somebody who didn't file for divorce till 12 years after, and their date of separation was 12 years before. So it really depends. If you are not clear on it, filing a petition can help you establish it if you guys are living together and you need to establish it. But it depends on your own fact-specific situation. So I know that's not what you want to hear, but hopefully it tells you should talk to somebody about it. I'm going to log off because I know we're done here and we need to end, but I do want to tell you, thank you for coming. You guys had a lot of great questions. A family law case, this is a big takeaway, can be super, super stressful. It never looks like you want it to look or like you think it's going to look in the beginning. That's not your fault. Maybe it is. Maybe you're the one driving the conflict, but a lot of the time it's not your fault. You should think about the case and think about the fact that you need to make it through this, and you will make it through it, but you need to have a certain peace of mind to do so. It's going to be really helpful for you in the evening to set a curfew on your divorce case. I'm not going to look at my family law stuff after 7 p.m. No emergency is going to happen overnight that's going to need to do that. Make some time for yourself. Get some help if you can. And feel free to access our online library of other resources as well. Thank you so much. Have a good day.
Thank you, everyone. Yes, we got to as many questions as we could. I know we didn't hit every one of them, but we tried to get to as many as possible in the hour. Please take note of contact information here, and we hope to see you again next time. Thanks so much.